Well, good morning and welcome to hsa-bc's webinar, Rent Issues and Support for Tenants During the Coronavirus Outbreak. My name is Sarah and I'm your host for today. So when you're typing into the question section, that's me who you'll be talking to. And now you have a face for the voice that you're hearing right now. It's a very stressful time for many of us, as well as those we provide services to. So I just want to start off by saying thank you for taking the time to join us today. And hopefully the content that we provide will help you to lead well and with courage in the midst of this crisis. So I'm also going to run just a little poll here, and this really helps our instructor Andrew and me to know where you guys are coming from. So just take a minute and tell me what your role is in your organization. And I've been in frontline work for long enough to know that sometimes it might be all of the above. We've only given you the option to select one. But if you do choose other, feel free to let me know what that other is in the question section, and I'll make sure to mention it. Good. We've got a lot of caseworkers and counselors on the line today. That makes sense as we're talking about working with clients to help them with their housing issues. Support staff as well, very crucial, and it's great to see some managers and supervisors on the line today as well. And some people are saying they have multiple roles, which is why they clicked other, and that's good too. So thanks for sharing that with me. All right, here's the best part. I get to introduce Andrew to you. Andrew is the Executive Director of the Tenants Resource and Advisory Center, and he started at TRAC way back in 2010, and he's been the director there since 2013. He's also on the Vancouver Renters Advisory Committee and the POVNet Board of Directors and the Residential Tenancy Branch Operational Stakeholders Committee. And Andrew has always worked in the nonprofit sector, and right now I know he's been doing a lot of advocacy work and meeting with different levels of government to help tenants during this crisis. So thank you for being with us today, Andrew.
Thanks, Sarah. Yeah, it's always a pleasure. You're right. It's truly unprecedented times, and especially leading up to the 1st of April, there was a lot of, I think, panic among the renters in the province, and a lot of efforts made by TRAC to affect some systemic change in terms of putting in place temporary law reform and enhanced protections for tenants who lost employment and were scared they couldn't pay rent, and were facing other issues like wanting to quarantine and their landlord entering when they, when they just wanted to be left alone. And so it was a crazy second half of March, and we'll touch on a lot of what I just mentioned there today. And I guess one other thing I should just mention, I've been the ED at TRAC since 2013, but I'm not a lawyer myself, and so as a bit of a disclaimer, this is all just legal information, and unlike some of the other ongoing webinars, recurring webinars that I do, this is brand new content, and so bear with me as I sort of move along here today, because this is all new for all of us here. But yeah, and I can give my contact information later. I can also give the contact information for Susanna Modrovic, who is our staff lawyer for our housing law clinic program, and a great resource if you're looking for actual legal advice from TRAC.
Oh, I can see you moving the mouse, so you're good to go.
All right. It always just takes a second to click in there. There we go. All right, so COVID-19, how does it impact BC renters? Before moving into that, I'm going to do a very brief, even more brief than normal, just overview of TRAC and our services. So hopefully everyone knows what TRAC does and who we are. We've been around since 1984, and we promote the legal protection of residential tenants across BC by providing information, education, support, and research on residential tenancy matters. Got an angry review on our website the other day that we don't have enough supports for landlords. on there, and got a bit of a chuckle out of that. We're funded completely to provide advocacy and legal assistance to renters only. So our services are mostly still fully operational and up and running. First off, we have our tenant info line, which is a Monday to Friday phone service. We offer direct advocacy at a couple different levels now. So we have our legal advocate, Michelle Bita, who offers representation to eligible renters at the residential tenancy branch's dispute resolution service. March 25th, the government finally announced their plan on how they are going to support tenants and landlords through this crisis. And so the plan included three things: amendments to the Residential Tenancy Act, operational changes to the residential tenancy branch's dispute resolution system, and financial assistance for tenants / landlords. So that was the plan that they came up with on the 25th. And then for 5 days, there was a little bit of uncertainty, but thankfully on the 30th, they made all of that official and passed a ministerial order to amend the Residential Tenancy Act. And on the same day, the Residential Tenancy Branch issued 2 guidance documents for the public and for their arbitrators called Practice Directive Extending Timelines and Director's Order Email Service. We'll start off talking about the eviction moratorium, which was the part of the plan that grabbed the most headlines and garnered the most attention from renters. So with any new eviction notice that a landlord issued on March 30th or later, they are of no effect and do not need to be disputed at the residential tenancy branch. So again, any eviction notice that your landlord issues you is basically void. It has no effect. Now, the one exception to that is if a landlord has a renter who is doing, extremely serious damage to the property, or is behaving in a way that just goes so far beyond anything that's acceptable, that landlord can still apply to the residential tenancy branch for an early end of tenancy and order of possession for extreme circumstances. So that is still possible. So even though your landlord can't serve you an eviction notice to get the process started to kick you out, they can still, for those extreme circumstances, go directly to the branch and apply to have you out. So that's for new eviction notices. When it comes to previously served eviction notices that were given to a renter before March 30th, those eviction notices are still in effect and should be disputed if the tenant doesn't want to move out. And if the tenant loses the hearing, an order of possession can be granted to the landlord in those cases.
All right. So one of the questions I asked people while we were waiting for the sound to get back was what they're facing right now. And a lot of them were saying that their clients think they don't have to pay rent because of the moratorium. But what you're saying is that landlords can still be granted an order of possession if a client loses the dispute hearing, okay?
Correct. So it's all a little complicated, right? So like if a tenant doesn't pay rent, say, if a tenant didn't pay rent on April 1st, the landlord can't issue a 10-day notice for that, because that issue would be of no effect, right? But if there was a previous eviction notice for, say, noise, the violation of quiet enjoyment issued, say it was a 1-month notice issued in the beginning of March, and that hearing moved forward, the landlord could still obtain an order of possession for that case.
Okay.
And there's as you'll see throughout this presentation, there's multiple levels to sort of to this. There's multiple stages, and so yeah, I don't want to get too far ahead of myself, but we'll definitely be sort of touching on, even if your landlord does get an order of possession, can they enforce that? That's still coming in the presentation here.
Okay, good.
Yeah, yeah. But yeah, and in general, the message from the government is, you still have to pay rent. Your landlord can't issue you an eviction notice if you don't, but you are still responsible for paying rent. Okay, so extreme circumstances. So on the previous slide here, I mentioned, again, the landlord can still go to the RTV and apply for an order of possession in extreme circumstances. So basically that means Section 56 of the Residential Tenancy Act. So I won't read this word for word, but you can pick out some of the words here. Significantly interfered with or unreasonably disturbed, seriously jeopardized the health or safety or lawful right, illegal activity, significant risk, extraordinary damage. So, these are the grounds on which a landlord can still go to the branch and try to get a tenant out of their rental unit, during this public health emergency we're facing. Now, in addition to these grounds, a landlord can also go to the branch and ask for an order of possession if there is like a government order telling them to do this, or if the tenancy has been frustrated in some way. But generally speaking, I think what's written on the slide here, this is going to be most commonly what a landlord would rely on. And so in this presentation, anytime you see sort of quote unquote extreme circumstances, that's just the phrase we've decided to use to sort of cover this slide, because it comes up quite a bit.
I'm just going to ask a general question that you'll probably get to, but just to put it out there, a lot of people are talking about how the no eviction, it applies across the board to everybody, whether you're affected by COVID, like losing your job or not. It's just if an eviction order is issued after March 30th, it's not effective at this time. Is that correct?
Correct, for everyone.
For everyone, aside from the things we just talked about in terms of harm and that kind of stuff.
Right, and an eviction notice doesn't have to be served in those cases, right? It's the landlord can sort of skip that serving of eviction notice phase and just go directly to the branch,
right,
and apply for an early end of tenancy and order of possession.
Good.
Yeah. So yeah, I think that the government took the stance that the most important thing is that social distancing and keeping everyone in their home during a pandemic is the most important thing, right? If there's a tenant who's being too noisy, maybe that can wait until later to evict them, right? If the alternative is displacing that person and spreading the virus. So yeah, that was the stance that the government's taken. Okay, so moving on to, as I said, there's sort of multiple levels to all of this. And so when a landlord wants to physically remove a tenant, they have to obtain three things. So number one is an order of possession from the residential tenancy branch. And then from there, they have to take that order of possession to BC Supreme Court and obtain a writ of possession. And then from there, they have to take that writ of possession and hire the services of a court-approved bailiff to go in and actually physically and legally remove the tenant and their possessions. So that's the proper process for physically removing a tenant. Now, this is where it gets a little complicated. We already learned in the previous slides that during the moratorium, the RTB will only be granting new orders of possession for extreme circumstances where the tenant is causing major problems. But what about previous orders of possession? What about, circumstances where the landlord applied before March 30th? So the ministerial order, while somewhat confusingly worded, is still positive for tenants. It's good for the most part. But according to the new ministerial order, a landlord must not file an order of possession in the Supreme Court. If they do, it may be refused for filing and returned. Now, this is going to be a common theme throughout the presentation. There is that exception. So if the landlord has an order of possession that relates to an extreme circumstance, then yes, they might be able to file the order of possession at Supreme Court. So that that was dealing with orders of possession. Now what about writs of possession? So for any new writ of possession, what the ministerial order says is, if a writ of possession is granted after the date of the eviction moratorium, the landlord must not seek to enforce that writ of possession with a court-approved bailiff during the moratorium. Again, there is that exception. If it's an extreme circumstance, our understanding is that you can still take a writ of possession to a bailiff and enforce it. So that's for new writs of possession. For previous writs of possession, what the ministerial order says is, instead of enforcing writs of possession promptly, quote unquote promptly, bailiffs have been instructed to enforce them, quote unquote, at the time when the eviction moratorium no longer applies. Once again, there is that exception for extreme circumstances. So as I mentioned, that's all great on paper. That's well intentioned and great on paper. But the $1 million question is, despite what the ministerial order says, will the Supreme Court and bailiff companies follow the order and refrain from enforcing orders of possession and writs of possession? That's what we're still trying to figure out and see how everything plays out. But on paper, there are some protections there now in terms of barriers to enforcing orders of possession and writs of possession. As I mentioned, the most important thing right now is keeping people and keeping renters in their homes and preventing unnecessary displacement. So we are monitoring this situation along with some other advocacy organizations. And so if any of you do encounter issues with this, please do let us know. The final bullet there, we have heard anecdotally that there are bailiff companies who are reluctant to remove someone if they're sick. So take that for what it's worth. That's just something we've heard through other advocacy organizations. It's in no way advice or anything to prevent enforcement of a writ or anything like that. But we just thought we'd mention that if someone truly is sick, and I think this makes sense, there are bailiff companies out there who might be reluctant to remove that person. So as I mentioned earlier, most residential tenancy branch dispute resolution hearings will be moving forward as scheduled. Most of them are done over the phone. A lot of the application process and evidence submission process can be done online. So yeah, most of them are moving forward as scheduled. Now, with in-person services being suspended at the residential tenancy branch, And most advocacy organizations, such as TRAC, the RTB has released a new guidance document called Practice Directive Extending Timelines to reduce access to justice issues and procedural fairness issues during the COVID-19 pandemic. You think about the senior in the West End who now has no RTB office to go to, doesn't have internet access, doesn't have, the West End Seniors Network or other advocacy organizations available to go to, isn't supposed to be interacting with friends or family members. What do they do if they receive an eviction notice, or well, I guess they can't receive an eviction notice. What do they do if their landlord sort of involves them in a dispute resolution hearing? And so that was a big concern we communicated to the government, and so they've created this document to address those concerns. The document deals with circumstances where the current pandemic prevents or delays people from making an application for dispute resolution, applying for a review, or submitting and or serving evidence by a required deadline. And there are, I encourage you to look through the document itself, but there are two key points in it. One, it says arbitrators have been directed to consider the pandemic as a factor that is quote unquote beyond the party's control when determining if an adjournment is appropriate. And arbitrators have been directed to consider the pandemic as an exceptional circumstance when considering extending time limits. So these were two things that we really wanted to point the RTB's attention to. There has to be a willingness to adjourn hearings. You have to lower the bar for adjournments for people whose natural justice and procedural fairness would be affected because they can't properly access the system right now. And so thankfully they've come out with this directive for arbitrators. Again, if with hearings moving forward, if any of you do have clients or friends or family who are experiencing access to justice issues, this is a big priority focus for us moving forward as we monitor everything during the pandemic. So please contact TRAC if you encounter any issues. A reminder that we now do judicial reviews at Supreme Court on this very topic, dealing with procedural fairness and natural justice issues. Illegal lockouts. So unfortunately, there are still landlords who are trying to ignore the proper process for physically removing a tenant and just throwing their stuff out on the street, changing the locks, bringing in a couple guys to physically remove the person. So there are still illegal lockouts happening. And so I wanted to point out that the residential tenancy branch's enforcement and compliance unit is still available to intervene in these types of illegal lockouts, as well as other serious and urgent matters. So this, if any of you out there haven't heard of this new unit, it's not new anymore, but it's fairly new. It's been great. It's been a great addition to the branch. So they have a staff of people now who can intervene in. This was sort of the top thing we told them to look out for, illegal lockouts. But any sort of serious and urgent dispute between tenants and landlords, they can actually go out and investigate, issue warnings, and sort of get the administrative penalties process started in the most serious of cases. So just know that this enforcement and compliance unit is still available. Okay, so another big question we've been receiving is, as a tenant, I gave notice to move out because I wanted to move out, but now that the pandemic has hit, I definitely don't want to move out. What do I do? Well, if a tenant served a notice to move, like at some point in March, if they serve that notice and they're expected to move out on April 30th, there's, that notice is still effective and valid. And so the tenant is still expected to move. If the tenant doesn't move out and overholds on the unit and lives there in May, the landlord might be able to obtain an order of possession by applying to enforce the tenant's own notice to move out. Sorry. So this is another one of those tricky situations where, even with this moratorium on evictions, the landlord wouldn't have to issue an eviction notice in this case. They could sort of directly go to the tenancy branch and apply for an order of possession to enforce the tenant's own notice to move out. So keep that in mind. The landlord can still obtain an order of possession for an overholding tenant. However, the landlord might not be able to enforce that order at the Supreme Court until after the moratorium is lifted, because it's not an order of possession that relates to one of those extreme circumstances that we were talking about.
So it sounds like to me that there's going to be a reckoning later, and actually a couple people have brought this up, the idea, their concern around what happens when the moratorium is lifted. Are we going to see a tsunami of evictions for notices or for issues that have built up during the moratorium period? Guess you don't know the answer to that, but something people are concerned about.
I mean, that's obviously that would be a nightmare moving forward, right? You can't just delay or postpone this. You can't just delay and postpone mass evictions until later. That's just not the solution. And we'll touch on this a little bit later, but the Premier said no one will be evicted due to COVID-19. And so at TRAC, we're going to remember that and hold him to that. And, it doesn't matter if it's the day after the moratorium is lifted or during the moratorium or, a year after the moratorium is lifted. There are going to be a lot of renters who are going to still be in the hole and probably never recover the income that they lost due to this crisis that was out of their control. And so I think there has to be government action to help those people, not just survive right now with an eviction moratorium, but down the road recover from the crisis with significant financial support.
But as it stands right now, we're still telling people to pay their rent if they can, and to act in a manner that assumes there might be consequences later. Hey.
Exactly. That's all we can tell people for now, because that's all the government has indicated to us.
Mm-hmm.
Yeah. Okay, so moving away from evictions, the other most common question we were receiving from tenants when all of this this crisis sort of hit us was around building and specific rental access or rental unit access. So, tenants were complaining that their landlord was still having open houses and trying to invite in the handyman to make just minor repairs during this time when renters are trying to social distance and quarantine. So this was another focus of our recommendations to government, and thankfully they made some really positive changes in this area. So what the ministerial order says is that landlords as well as agents of landlords, can now only access a tenant's individual unit for emergencies, such as emergency repairs, or with explicit consent from the tenant. So no open houses, no showings, no routine maintenance allowed. Renters are now allowed to properly quarantine and social distance themselves. Previous notices to enter are also null and void. So, you can provide notice to enter up to a maximum of 30 days in advance. So if there is still cases where there could be notices that would have previously been valid, that they are now null and void. So that's related to a tenant's individual unit. When it comes to the building in general and common areas, what the ministerial order says is that landlords can restrict the use of common areas by tenants or guests if the restriction is necessary to protect the health, safety, or well-being of the landlord, the tenant, and occupant, or guest of the residential property due to the COVID-19 pandemic. So during these times, it could be completely reasonable for the landlord to say, okay, no, the games entertainment room is now closed. I'm going to set a limit on the number of people allowed in certain common areas like the shared laundry room. Perfectly reasonable measures to take as a landlord. One key thing to point out here, landlords still can't prevent or interfere with the access of a tenant, another occupant of the rental unit, or the tenant's guest to the tenant's rental unit. So if you have mobility issues, if you are a senior, if you have barriers to supporting yourself during these times on your own, you do still have the right to have someone visit you and drop off groceries or support you, otherwise support you during these times. So the landlord can restrict use of common areas, but they can't say your friend or your family member can't come to your specific unit and provide supports.
And this question always comes up when we talk about guests, especially in an SRO or a supportive housing context. So would this apply also? Because I know there are definitely housing units in Vancouver's downtown east side that have restricted guests now due to the pandemic.
Yeah, it's a very complicated topic and a bit of a gray area. Even before this ministerial order took effect, they slightly amended the law previously to say that I don't have the wording in front of me, but basically previously landlords were still allowed to restrict guests. It said landlords cannot restrict guests unreasonably, basically. So you could still put forward an argument that if you're running an SRO, it's reasonable to to have a sign in at the front entrance, and then it would be up to an arbitrator to sort out the details there and rule on the matter. But even previously, I wish I had the wording in front of me, but yeah, basically landlords were allowed to put reasonable restrictions on guests, I suppose.
Yeah. Okay. Thanks for clarifying that.
Yeah. All right. So the rent freeze. This was a phrase that I think was misunderstood by some people. I think some renters out there thought that meant you don't have to pay rent anymore. What it really means is that landlords can't raise rent until further notice. So this rent freeze even applies to previous rent increase notices that were served potentially months ago. So even though this again came out on March 30th, so any rent increase that would have been effective for April 1st then became no longer effective. So that's basically what they meant by a rent freeze. And landlords can still issue rent increase notices currently during the moratorium, but they can't take effect until after the moratorium is lifted, until after the pandemic is over. Okay, financial assistance. So we're still waiting to hear a little more about some of these programs, but sort of listed the main ones here. There's the Canada Emergency Response Benefit, where you can apply for $500 per week for up to 16 weeks. There is the BC Emergency Benefit for Workers, which is a one-time payment of up to $1,000. And then specifically related to renters, there is the BC Rental Rebate, which Premier Horgan and Housing Minister Selena Robinson mentioned in their announcement. We're still waiting for the application process on this. My understanding is that the whole process will be administered through BC Housing, and that applications should open up in the middle of this month, so hopefully soon. And the idea is you can apply for $500 per month for, I thought it was 3 months. It might be 4 months, so for 3 or 4 months. And the idea is the tenant applies for the rental rebate, but the money gets sent directly to your landlord. So it's essentially a landlord subsidy. And then finally, if you're already on SAFER or RAP, the rental assistance program for families, and SAFER is for seniors, you could have adjustments made to these programs. So that's something you're going to want to look into. So as I mentioned earlier, these measures and the other legislative operational changes we've talked about, I mean, we were actually pleasantly surprised when the government announced their plan. I think all the measures will help renters survive this crisis, but much more financial assistance and additional measures are going to be needed to help them recover. There's no point of just kicking the eviction can down the road until later and then having, as you said, Sarah, a tsunami of evictions. That just can't be the solution here. And again, the Minister of Housing and the Premier have both said no tenant will be evicted due to COVID-19. And from our perspective, that means if there's a tenant 6 months later who's still who's never realistically going to be able to repay their rent arrears, there has to be government action to help out that person and other renters like them. So yeah, our plan is to sort of shift our attention from lobbying for sort of the temporary law reforms that are in place now to more long-term solutions that'll help renters and landlords recover from this crisis. Okay, so service of documents. So again, there's in your handouts there should be the 3 key documents here. So there's the ministerial order, there's the practice directive on extending timelines, and then the third one is director's orders email service. And this is just a one-pager, but it's a document that basically says email, documents can now be sent by email. As long as you can show that the other party received your email, or you have sent the documents to an email address that the other party has routinely used to correspond about tenancy matters. In addition to email now being an approved method of service under the Residential Tenancy Act, personal service of documents is currently prohibited under the Residential Tenancy Act for as long as we're dealing with this pandemic. Okay, and so that's basically the presentation. I did want to add just this final slide. There are a lot of renters, quote unquote renters, who don't fit the definition of tenant under the Residential Tenancy Act, right? You can have roommate situations, homestay program situations, where you can't access the residential tenancy branch's services. And so in those cases, your legal recourse is to apply to the Civil Resolution Tribunal to resolve those legal disputes. And so I just wanted to pass on a message that we received from the chair of the CRT. They've made a couple minor changes to their applications for extensions. So again, sort of getting back to this idea of access to justice, if anyone needs an extension of time, they can email info@hsa-bc.ca. And the CRT already has a pretty good, it's already pretty affordable, and they have a pretty good fee waiver process, but I think they're even expanding their net for fee waivers even more widely. So if you're wanting to apply for a fee waiver or have any questions, you can also email info@crtbc.ca. Yeah, I think that should cover it here. I'll throw on our contact info there. But yeah, I'm happy to answer any questions and stick around as long as I need to here.
Yeah, we've got some questions here. Thank you, Andrew. We were talking before the presentation about how there's always wiggle room and there's always unintended consequences of even emergency changes to law. Mm-hmm. So here's a good scenario example. Someone's client received a notice of rent increase, which is set to take effect on June 1st. And the notice was given before everything started. So would that notice not now take effect until everything is over? Or what would be the case there? So people who've received rent increase notices that take effect, this summer or in June, but were issued before all of these other measures came into being.
I think we have to wait and see. I think, so let me think. So it's still my understanding is that notice would still be valid, but couldn't take effect until after the moratorium, after this ministerial order has been lifted. But who knows? The government could say, to help combat the effects of this pandemic, we're going to extend the rent freeze for another year. They could, who knows? Or they could say it's effective immediately. I guess we just don't know yet, right? Again, any notice of rent increase that is issued today, we know it will still be effective at some point down the road. So certainly any notice that was issued previously would still also be effective. We just don't know, I guess, when it'll become effective, or if it, or I suppose if it will become effective, but it is currently still effective, if that makes sense. Or valid, I guess, is the better word. Yeah.
Yeah. So, and people are asking a lot of these kind of questions. For example, someone who's on a 1-year lease with an expected rent increase on May 1st, would that rent increase apply right now, or not? I know you've already.
Nope. No, it should, as long as this order is still in place, their rent should not increase.
All right, so it's kind of like pushing the pause button on a lot of these notices of rent increase. They might apply later, but while the moratorium is happening, it's just on pause, hey?
Exactly. Yeah. As I said, even, the order took effect on March 30th, and any rent increases that were to take effect on April 1st were put on pause, even though the notice was served, 3 months earlier.
Right. Sorry, I apologize for a bit of background noise here. Okay, I'm going to carry on with questions. Um, so one of the caseworkers here has spoken to a family today who have been given a 2-month notice on March 31st for May 31st, and they're not sure about the reason, but that wouldn't be valid, would it?
Correct.
Yeah,
Not valid. Nope.
yeah. It's like you're just doing a yes or no thing here, which is fine.
Yeah. So yeah, I mean, my understanding is those, yeah, that doesn't even have to be disputed. And what they should probably do, if there's a landlord who's still issuing eviction notices right now, they're obviously not paying attention. So it would probably be best to notify the landlord in writing that, there is this order in place, and that any notice that you issue right now as a landlord is of no effect. Because if they're thinking it's still effective, even though even though it's an illegal notice, they might try to take action down the road, right, on May 31st. So yeah, it's always best, I think, to notify the landlord of what the law is.
Yeah, that's actually helpful. Do you want to just talk a little bit more about that? So you can send them an email, especially for people that are advocating on behalf of their clients. Could they use some of the handouts you provided to outline the law at the moment? Like, what would your recommendation be in general if people are receiving these illegal notices or rent increases? What kind of communication should they put together on behalf of their clients?
Yeah, so on our website, we have a series of template letters. None of them are COVID specific right now because we just haven't had the time to create any new ones or update them. But the general, there are, the general template is still there. And again, there's 28 of them, so you can find one that sort of fits your needs. I think we do have one on sort of responding to an illegal eviction notice. So that would be my recommendation, to go on our website. Right on the homepage, you'll see a box for template letters, and then you can find the one you're looking for in the list there.
Okay, great. And then rolling on with a few more questions here. And again, this is another scenario, and I think this is really helpful to just apply, what we've just learned. So if a tenant was issued an eviction notice before the moratorium, and they were supposed to have left the unit on March 31st, but the landlord has not gone for an order of possession, can the landlord still do that because the tenant was supposed to move out before the moratorium? If that makes sense. So we're kind of...
Yes, I believe so. I believe they can still. Yes, and so again, this is all sort of new for me too. So I'm trying to do my best to be as accurate as possible. I believe they still can. So you can't issue an eviction notice and get that process started right now. But if it was a previous eviction notice that took effect and now just needs to be enforced, I believe the landlord can go to the tenancy branch and obtain an order of possession. But the thing is, they probably then can't take that order of possession to Supreme Court and enforce it by getting a writ of possession.
Right.
Right? Unless, so yeah, basically, unless it relates to one of those extreme circumstances that we talked about, right? So what's likely is the landlord will go to the branch, obtain an order of possession, and then sort of the pause button will be hit again, as you said, right? Mm-hmm. And then as soon as the moratorium is lifted, we'll see how much protection the government wants to give renters. Like, who knows? Maybe that order of possession will become effective in 48 hours, or maybe they'll say, you know what, that would be crazy. we should give some extra time for the order of possession to take effect. Mm-hmm. So I think they can still go get the order of possession, but they probably won't then be able to enforce it at Supreme Court.
Right. So it's almost like there's a chain of events here, and at a certain point, we're all pressing pause. But as with, we all know about a pause button, there's a point in time where play might be able to be pressed again, hey? Um,
Yeah,
yeah. So it's not erasing everything, but it is putting certain things on hold for the moment. It's a tricky
yeah,
time.
exactly.
It's a tricky time, especially I think, to be a caseworker supporting your clients, because you know what some people were bringing up earlier is a lot of people even confuse the idea of the rent freeze and what that actually means. And then you have people who can't pay their rent because
Hmm.
they've lost the job that they had. Um, and they might not ever be able to pay that rent back that's missing. So
Yep.
um, I just want to acknowledge that it's a tricky time. And if you do have specific scenarios, like Andrew was talking about, um, what's that body called again? I totally forgot. It's like the enforcement unit.
Yeah, yeah, compliance and enforcement unit.
Yeah. Or if you just want to take your specific situation for your client to track. That's what they're here for. You can call them, talk to Andrew, talk to Susanna and some of the other lawyers there, and find out whether there's advocacy available or maybe there's some information that um, they're missing that could be helpful in keeping your clients housed at the moment. And then the other thing that someone's just bringing up here, which I think is an important thing to remember, is that this is a time to lean into our relationships and our ability to negotiate. Um, so, you know, being able to communicate and negotiate with your landlord or the landlord of your client, um, and, you know, talk it through before you get to an eviction notice or
Hmm.
a hearing or a dispute resolution. Um, we kind of assume, I sometimes assume that people are going to say no to me when it comes to things like rental issues. But sometimes, I mean, landlords might be in a position right now where they have a bit more grace, or they're not under financial pressure, or they're willing to work something out. So thank you for bringing that up.
Yeah,
Uh,
absolutely.
yeah.
That's such an important role of the advocate. Um, if we often say dispute resolution is a last resort, sometimes you have to apply for it immediately if it's a really serious issue, but most of the time, the first step is to put your concerns to your landlord in writing and sort of try to negotiate with them. And yeah, as an advocate, that can be such a big part of your job.
Hmm.
Yep.
All right, just a couple more questions here before we wrap up. Um, Thank you for asking these. This is the place to do it while Andrew's available to you right now. So another scenario here, a client who was provided with a previous eviction notice went through arbitration on March 31st, but didn't have access to a legal advocate due to COVID-19. So is
Hmm.
there a possibility that this person can appeal?
So did they ask for, I guess I would like to think that if that person said to the arbitrator, um, I don't have access to my legal advocate right now, the bar would be low enough that they would adjourn the hearing. So I don't know if that ask was made, um, but that might be a case where this person should contact our housing law clinic, which does sort of judicial reviews, but also gives legal advice on those types of matters related to procedural fairness and access to justice and things like that. So I should have this number up on the slide here, but um, to reach any of our staff's extension lines, the number is 604 255 3099. And then if you call that number, it'll give you a list of extensions. So Susanna Modrovic is our lawyer on staff who does our judicial reviews for that clinic program. So that's who I would that's who I would recommend contacting. I'll say that number one more time for you, to 604-255-3099, and her extension is 228, and mine is 222.
Okay. And then another question about validity here. What is the date where notices given are no longer valid for the period of the moratorium? Someone's asking about March 18th, but I think you said March 31st.
Yeah, any notice that was given before March 30th is still valid and should be disputed. So March 29th, I believe, would be the, yeah.
Okay.
Yeah.
So
Which is unfortunate, because like March 25th was the announcement from the Premier and the Housing Minister, where they sort of laid out the plan for what's in the order that became effective 5 days later. So there are these people who, in that 5-day window were told, basically you can't be evicted, but then we're given an eviction notice that is now valid and has to be disputed. So it was unfortunate that there was that 5-day sort of delay there, but yeah, any notice issued before March 30th should still be disputed.
Okay. And then just to kind of sum up here, I think it's important to remind people again that if you do have a client or someone that you're helping with an eviction or other notice that happens before March 30th, you need to take that to dispute resolution. And because, as Andrew said near the beginning of the presentation, dispute resolution is still in effect, is still ongoing. It is done over the phone, but they've just changed it a little bit so that you can get evidence in a different way. Yeah, maybe I'll let you just briefly sum that up again.
Yeah, and I mean, I think one of the important takeaways from this presentation is that there has been that practice directive issued to arbitrators, and I think we have to hold them accountable to listen to that directive. If there's a client out there who is experiencing any sort of access to justice issues related to COVID-19, again, I hope the bar is very low for arbitrators to like adjourn hearings or extend timelines. Yeah, because the system is moving forward, but the RTB itself doesn't have any in-person services available, which is a major access to justice issue in my opinion. All of the advocacy organizations that would normally provide representation to tenants, such as TRAC, we're all closed. Or we're all working from home and social distancing. We can't meet with our clients to help them apply for, prepare for, and participate in the hearing right now. So there are these major issues to having a fair hearing. And so, if you have a client who has a hearing that's moving forward, and you want to ask for an adjournment, do your best to put forward a strong argument that, directly and explicitly states, I think it would be unfair for this hearing to move forward at this time, due to access to justice issues related to COVID-19. And I would hope that that an arbitrator would listen to those concerns because of this directive that's been issued, and adjourn the hearing until a later time, and so that'll sort of buy you some time. And yeah, that's my hope. At least we're trying to monitor the situation moving forward.
Yeah, and this is it's an interesting question. I've never had it asked before. What about people that are being evicted from RV campgrounds, which have a daily rate? Are they covered by the Tenancy Act?
Yeah, so the residential tenancy branch has a mandate to help out tenants and landlords in both residential tenancies and manufactured home park tenancies. So it's tough. At TRAC, we tend to focus on the Residential Tenancy Act, But as part of this ministerial order, there were also changes made to the manufactured home park tenancy. So I'm not an expert on the hsa-bc, but you can certainly call the residential tenancy branch and ask questions about that. But generally, the same rules and changes have been made for both acts.
Okay, and I think they were talking about like a campground where you park your RV, actually, not a mobile home
Right.
situation. But
Right. I believe that it's a bit of a gray area. I believe recently an advocate sent me a decision where I think someone in an RV park was determined to fit under the MHPTA. So it could depend. It could be very case by case. Again, I'm not. I'm definitely not an expert on the MHPTA and sort of that area, that side of things. So yeah.
that's okay.
If you email me at whoever this person is, if you email me at Andrew at tenants.bc.ca, I can put you in touch with someone who can answer your question for sure.
That's cool. Thank you, Andrew. All right. Well, there's no more questions at the moment. We're going to wrap up here. Any last words, Andrew? Any last encouragements or things you think people need to know?
Yeah, I mean, I think just speaking to our staff who are on the phones on a daily basis right now, there seems to be, there was a spike in calls there for a while leading up to the first, and now it's died down a little bit, but there's still this, I think there's temporary relief that you can't be evicted right now, but there's growing concern at the same time that, and it's come up a couple times throughout the presentation, what's going to happen when the moratorium is over? What's going to happen when the order is lifted? Am I going to suddenly owe all this rent, even though I don't have a job? I think there's a lot of people who are temporarily relieved, but really concerned about the future. And so from a systemic advocacy standpoint, that's something TRAC will be focused on moving forward. I think we have a fairly good relationship with the Ministry of Municipal Affairs and Housing and the Residential Tenancy Branch, and I'd like to think they listen to us about our concerns for renters, and so I'm really hoping they can put in measures and sort of take action that help help all renters recover from this unprecedented crisis that we're facing, because it's going to be a huge recovery process moving forward.
Yeah, well, thank you, everybody. And this slide has been up here for a while, so I'd really encourage you to connect with TRAC. They have phone lines. They have lots of ways you can connect with them around getting the help that you need, and continuing to ask those detailed questions about what you can tell your clients and the people that you're advocating for right now. You'll see on our website, there's a whole section on coronavirus and sector resources, and under there will be all of the video. We're actually in the process of releasing all of our webinars around this topic as an audio file, so you can listen to it in your podcast feed while you're driving to work or while you're folding your laundry or whatever you're doing. And there's just a bunch of resources there. All of the handouts, all of the video, all of the presentation, all of the audio will be up there for you. So feel free to access that there. And as always, you can get in touch with us directly via our website. You can give us a call. You can send us an email, because basically what we're doing right now is providing as much information and translation and help to you so that you can do your job well during this time. So we're shaping our training in real time. And so we really appreciate hearing from you and what you need. And Andrew, I just want to say thank you again for being here today. Thank you for answering the unanswerable questions and continuing to advocate for renters and tenants in BC. I really was encouraged by you talking about how the ministry had been listening to TRAC's suggestions. and had put some things in place based on what you guys had asked for. So hopefully they will continue to listen to you and get some more advocacy going for the long term, hey?
Absolutely. Thanks for having me, Sarah.
And thanks everybody for taking the time to be here today. And please get in touch with us anytime. Thank you, Andrew. Take care, everyone.